Hey everybody, it's Kevin Rogers here, and thrilled to have my friend Peter Hoppenfeld on the line with us. Hey, Peter.
Hey, Kevin. Pleasure to be here.
Thanks for doing this, man. I really appreciate it. As you know, I've got the Copy Chief community here, and somebody had a legal question, and of course, I thought of you right away.
Thank you.
You are, as we explain, either an attorney who really understands marketing or a marketer who happens to be an attorney. Have you ever decided which of those titles is the most appropriate?
It's depending on the conversation I'm having during the day. It's flip flops like a couple of dozen times a day. But it's I guess it's part of why the package sells, so to speak, right?
Right. But you work with a lot of high end, well known marketers, people who sell stuff online. Been in the business a long time, and you work with Ryan Lee and a lot of other people. I met you through Ryan.
I do.
And so thanks for doing this. Really appreciate it. And
my pleasure. Anyway, anytime I can be of support to you in the community, I'm here.
Thank you, Peter. Appreciate that. So the first question is from Ross, and he has a very specific question about music copyright. So he's reached out to an acoustic duo he knows to create their own version of a popular lullaby. Mm-hmm. So he's going to underlay it with compelling images of the product he's selling, add a nice little thematic tagline at the end. His question is, with the copyright issues of the lullaby, he says, we'll be creating our own cover version of this, not using the original in the video, but he wants to better understand the copyright issues about whether he can do that. Do we have to pay royalties? How do we even begin to find that stuff out? And Google hasn't gotten far.
Right, and the answer is yes. So the fact that it's a cover version is really irrelevant to the owner of the composition.
Okay.
So just to kind of put it in context, there are any number of rock and roll performers who the song comes up because I heard a cover yesterday. Not Fade Away. Everybody and their uncle has performed the song,
right.
But the writer of the song gets a royalty every time it's performed. So the fact that there's a cover is not the relevant issue. Now, as a lullaby, there is one thing. Depending on what the lullaby is, it might be in the public domain. If it's a song that's been around for generations,
mm-hmm.
the copyright laws only go back so far. But what your community member should be doing is, a good Google search will bring you to the publisher of the music. If it's been recorded, you can go to BMI or the oh God, I'm losing the name of the other major licensor, but you can search and find the major licensing entities that cover the ownership right to songs.
Yeah, somebody mentioned
BMI
the Harry Fox agency.
Yes.
Is that it?
Yeah.
Okay, great.
That's another one. But even like the simple things, just to throw out superfluous information that people might find interesting. If you show up, you're running a live event, and you're running background music for the event, and they have a large enough crowd, theoretically, but technically, you should be getting a performance license to play that music.
Wow.
It doesn't happen all the time, but for larger events, it should. And so the monetary stream to a performer or a writer, just like for somebody writing words, doesn't end. Okay.
Right. Interesting. Okay. Yeah. I think that's a common thing that most marketers who've been around a minute know you have to get rights-free music. But sometimes people will say, screw it. I'm going to slip in this AC/DC song in my video.
Right.
And I think the assumption is, well, what's the worst that can happen? I'll get a cease and desist, and I'll just take it down and change it. Is that realistic, or what are we really flirting with here?
Yes and no. But I'll give you an example. Getty Images is well known for policing the use of their images, and at least half a dozen times a year, a web designer, internet marketer with a landing page will call me up with a letter from Getty Images because they picked something off the web to throw into, an offer, not realizing what the impact was of that copyright. And Getty Images won't just say, take it down. They'll say, pay us. And they have a scale, and they will collect. So, it's not something to ignore. You also need to balance the impact of the use against the cost.
Mm-hmm.
It's hard to say, I can't give you on a scale of 1 to 10 what your risk is. Also, obviously, the more impact the piece has, the more risk you have that somebody's come knocking at your door.
Right. Okay, good. Interesting. Good to know. So, yeah, just play it safe. I mean, there's so much good rights-free and royalty-free images and music. I mean, for pennies, sometimes you can get really good-looking stuff. And
even on, back to the original question,
mm-hmm.
the cost of getting a license to this cover is not going to be large. Okay, it's not.
Oh, okay, yeah, that's a good thing. That I didn't even thought of that. It just
sounds
like something that would be expensive.
Typically not. And if it's a residual royalty, if you're making money, sometimes it costs money to make money.
Right, and
money well spent.
How complicated is the process? You sort of
not that complicated. Once you find the owner, it's not complicated at all.
Okay, good to know.
You're not reinventing the wheel.
Okay, great. All right, let me a couple more questions here. Since I put it out, so I knew I'd have you on the phone, I thought let me corner Peter here. And a couple other people. So Chris was asking, what allows you to end a contract? He says, in his case, I have no cancel contract or void contract clause, yet the client has broken it. Would that be suitable grounds to end the contract?
Well, it depends what you mean by broken. They haven't paid you. They haven't performed. It really depends what the circumstances are.
Mm-hmm.
But, unfortunately, a lot of times, documents get put together, slapped together, cut and pasted, and oops, we forgot to put a termination, have a specific term or a right to terminate. So lessons to be learned. I mean, I always like to give you takeaways. The takeaway is, make sure there's a time limit on a document. Make sure there is a right to leave it under certain terms and conditions, but have some exit strategy. When there isn't one, it really comes down to fairness, and hopefully you're still involved in a conversation. If you're owed money and you're not getting paid, put the party on notice, notwithstanding that there's no specific termination rights. Nobody is going to expect you to keep working if you're not getting paid. Have the conversation and say, this isn't working, and while you might continue to want to pay me, I don't really want to continue the job, and let's agree to amicably end this in X weeks, months, whatever.
Right.
Conversation, sometimes people forget to reach out, take care of it.
Right.
So
that's a good point. I always kind of say that, the contract's about as good as the people signing it. I mean, things are enforceable, but I think what you're saying is at the end of the day, it's still communication. And if things go a little sour, if you're really looking for them to break the contract, then that probably means you just don't want to be in it. Maybe, just be forthright about that.
Right. And, I'll give you an example. Just in the last 2 days, a client, without sharing the document with me, subscribed for a new shopping cart situation, provider. Guess what? It had a 12-month term. It didn't have a early termination clause. When they started playing with it, they realized that, what they had was working just fine, and the transition wasn't going to be worth it, or the benefit. And, the client asked what to do. And, as I was getting back, I got a message, we spoke, and they agreed, to let us out after 2 months. So, you can always find reasonable compromise when you have reasonable people talking in a reasonable way.
Mm-hmm. Right.
And, if people are up against the wall and screaming and yelling, it's always more difficult to work a resolution. But I want everybody to also keep in mind, everybody's worried about getting sued. For small matters, given the nature of litigation in these United States of America and the cost involved, people aren't suing each other so fast. So,
yeah.
You have to balance what the thing is worth as against what it could cost you to fight the fight. So, sometimes it's better to vent and scream and yell and then come back to the table as a reasonable human being, evaluating the positives and negatives and putting ego aside and hurt feelings aside and move on.
Yeah, sound advice. That's the truth. It really is. Yeah. It's always emotional. That's usually what's driving things. So
right, of course.
Good stuff. Okay, and finally, Lizzie has an interesting question here. She's asking, she's in Australia, So she's asking, how does copyright work with online courses? For example, she says, if I want to make a course on crochet and I cover the same topics as another course, is that okay or not? She says she knows in Australia with recipes, you're allowed to use the same ingredients, but the instructions have to be your own words. And she didn't know what rules apply when it comes to, say, a craft project or something like that.
Well, there are certain things that are in the public domain, that meaning they're just common knowledge, that aren't really protected. Mm-hmm. So, I would say that the process, just to use for example, the process of crocheting is not something that any particular person owns. Mm-hmm. There might be patterns, there might be novel approaches that somebody's created that are in fact theirs, okay, that you need to give credence to. In other words, whatever is unique amongst this public domain situation, you could theoretically own. Copycats is a common question that comes up. Some things are protectable, some things aren't. As writers, everybody on this call or listening to the call understands that, if you write a sentence, a catchphrase, it's protectable to a certain extent. But if you look back in time over the history of hooks, which certainly, Mr. Rogers, you are have a PhD in, what's old is new again.
Right.
But knocking off verbatim, the content of training programs and the like, and just changing labels, well, that goes beyond what's fair use. So there are fair use concepts, there are public domain issues. It's hard to give you a generality, but, the key, again, I think, is to be reasonable and fair, and acknowledge those that you're gaining insight from and emerging into your own work, and at the same time, putting on an expectation to your audience that what's yours remains yours.
Yeah, great advice. And what about, if you title things, what is the actual process of, say, trademarking? Like if I create a course that's copywriting, I'm not reinventing the wheel here. Some of these principles have been taught different ways, but I'm giving each mechanism a title. Does that begin to give me more ownership of it?
Well, it can. So, but understand, let's just give you the basics of what we're shifting from copyright, meaning content, to trademark, meaning label.
Right.
Okay? So, certainly, there have been recreations and reincarnations of most, for example, personal development courses forever. You couldn't count how many reinventions of Napoleon Hill are out there. Okay? Right. We get that. Mm-hmm. But where we start having issue is when, and it's probably the part of the process that most marketers, content creators tend to give short shrift to, and that's the whole process of labeling. So trademark law in a nutshell. Trademark or a service mark is a label given to your product or service for which you want to claim ownership. Under common law, meaning just general law and now codified in the U.S. and in most countries in law, a trademark can't be purely descriptive. So you can't trademark ice cream for ice cream. A trademark, first use wins. Whoever used it first for this type of product or service has the first right. Okay? And certainly if it's registered, meaning, you put on a filing and registered the trademark, that gives you presumptive rights above and beyond anybody else. So what are you supposed to do? You're supposed to do you should be doing a search to make sure that the label you're giving to this product that you've worked your ass off on gets the same amount of attention to make sure, number one, that somebody else isn't using it, and if they are, is it infringing? And number two, it hasn't been registered before. And is it even protectable? And does it have any other hidden meaning? Mm-hmm. And that's something I think, we always talk about this, Kevin. It's not just what you say, it's how people hear it. Okay? So I can't tell you how many inappropriate trademarks I've seen because people are in their own little world and don't realize it could be offensive to somebody else. So put it out there, okay?
Interesting.
But give it, if it's something that's going to be very highly visible, it makes sense to have a trademark search done by Trademark Counsel. It's money well spent. Because the last thing you want to do is to have a course out there which you've invested in printing, in web design, in putting out to, and successfully selling, and have somebody knock at your door and say, pay me. Okay?
Right. Yeah, that's great advice. And one last question on trademark. Is it a problem to put a TM for something that isn't really trademarked?
Yeah, no, it's not a problem because, again, it's the two sides of protecting intellectual property. There's the common law side, meaning the usage side, where it's all about notice, saying to the world, this is my label and I own it, okay?
Mm-hmm.
And you could simply protect yourself by putting a TM, a superscript TM, next to that phrase. And to take it to the next level, to get presumptive ownership, you would go through the process of registering it with the Patent and Trademark Office. And when you finish that process and get a certificate suitable for framing, you then put an R in a circle, meaning a registered trademark. But in fact, the best approach is once you have determined that you have a mark that's not purely descriptive, that somebody else has already owned, and you're going to use it, right away you should be putting a TM on a website, in copy, on product, boxing or labeling. Put that TM. It's your notice to the world. Hey, it's mine. Just like you put a copyright notice at the bottom of your content, you put a trademark notice on your labels.
Great. So it kind of sets the intention that lets people know, hey, this is mine. I'm serious about it.
It's you putting your hand up and saying, hey, it's mine.
Yeah. Interesting. Good to know. Great. Peter, I want to respect your time, but I really appreciate you doing this for us today. And I'm sure it'll be, all the members will really appreciate it as well. And we'll be talking again soon, I'm sure.
Anytime you have a question, feel free. My pleasure.
You'll be hearing from us again. Thanks, Peter. Appreciate it, man.
Thanks, Kevin.